Hey there, EB here on the Anything But Bland interim weekly update. I'm going to do a big weekly update at the end of this week, but I wanted to talk about the very informative, captivating Supreme Court arguments this morning in the Alex Murdaugh double conviction case. It was, I think, good theater. It was, as a lawyer, really good to see. There was some, really good advocacy done by all the lawyers. And the Supreme Court was well informed, and the justices asked some really pointed questions. I was shocked, I must say. I mean, I was wrong because I had thought that the Supreme Court would show greater deference to former Chief Justice Jean Toll and her decision to not use the Remmer standard regarding juror interference. And everybody should know that the Remmer standard is a federal court standard where it says all you have to show is that somebody interfered with the jury. And you get a new trial. Whereas the State v. Green standard, which he applied, says not only do you have to show that interference, but you have to show that it would have changed the outcome and did change the outcome of the juror's decision to vote Alex Murdaugh guilty of the double murders of his wife, Maggie, and his son, Paul. The hearing started about 9:35. Chief Justice Kittrick broke the hearing up in two parts. The first part was to address the issues of Justice Toll and her decision not to grant a new trial based on Becky Hill's alleged juror interference. The second part was on what I thought was going to be on the evidentiary issues. Hello, Miranda Graham, which I thought were only going to be on the evidentiary issues, but there were 5 issues that Jim Griffin identified that he was appealing. One was the cell phone testimony regarding the throwing of the cell phone and where it was found on Moselle after Alex left to go to his mother's house. The second was the gunshot residue, gunpowder residue, where it discussed it being on a blue raincoat, and he said clearly it was a blue tarp. The third, which was probably most of the arguments, though, was the 6 days worth of financial crimes and financial misdeeds that was introduced in the trial regarding Alex Murdaugh. The fourth issue that he never addressed and said, and the fifth issue as well, that was pretty much going to be relied on by him in the briefing done by the defendant, or at this point, it's the appellant, Alex Murdaugh, was Doyle v. Ohio post-Miranda violations, where he was questioned, even though that he invoked his Miranda rights. And then number 5 was the firearm testimony, which he said was just absolute junk science, where they tried to take bullet casings and say they came from the guns that killed Maggie and Paul, even though those guns were not found. I was shocked that the Supreme Court attacked Judge Newman. Dick Harpootlian did the first argument on the issue of Justice Toll's application of the State v. Green standard, her not letting in testimony from 2 alternative jurors, and how she construed the testimony of juror number 12. And he did a good job. He started off very slow. Of course, he was continuing to make his normal jokes, but he finished strong. I was pleasantly surprised to see the lawyering that he did. They really didn't ask him a lot of hard questions to the depth that they asked Creighton Wooders when Creighton Wooders got up. As I said, I always thought that they were not going to reverse this case and give a new trial, or reverse and send it back down to Justice Toll for her to apply the Remmer standard. Creighton argued that they had to take the facts and the record and the inferences from those facts and record as Justice Toll announced them. Dick Harpootlian called her Judge Toll. She deserves the right to be called Justice Toll or former Chief Justice, but be that as it may, I think the Supreme Court found on its own that there was enough juror inappropriate comments made by Becky Hill. I think we heard Chief Justice Kittredge talk about how he's responsible for all the clerks of courts and officers of the courts and the bailiffs in there, and that the public has to have confidence in their clerk of court. I think that the state lost the argument. Not so much because Creighton didn't do a good job. I thought Creighton did a wonderful job. He got a lot out, talked fast. But sometimes, trial lawyers who are trying to preserve their verdict try too hard. And that's why you bring in a fresh voice or a fresh set of eyes to make the appellate arguments, because they're a little less invested. They're not trying to preserve that verdict that they obtained. They're not trying too hard. They're more clinical, talking about the law. I thought that maybe there should have been a second voice from the state. Bob Cook, who is an excellent elder member of our bar, who is a tremendously good appellate lawyer. Maybe he should have argued some of those issues. The first part clearly showed that the Supreme Court believes that there was absolute interference, that Alex's right to a fair trial may have been affected by what Becky Hill did. And the fact that Becky Hill pled guilty to perjury was a big fact that I think has moved this Supreme Court. Also, the finding by Justice Toll, when she said that in her ruling that she didn't find Becky Hill to be entirely credible, I think John Few, the Associate Justice of the Supreme Court, aptly said, well, that means that she found that she was lying. That's the truth. And so even though 11 jurors, 6 that I represented, said that they had not heard Becky Hill say anything inappropriate, I think the justices between the 12th juror and juror number Z and the egg lady plus the alternate 741, I think that there was enough in their testimony and affidavits that moved the Supreme Court to believe that Becky Hill didn't just say ministerial things about when lunch is or when court's going to be over or when it's going to be starting. She was trying to influence the jury to make a decision on Alex's credibility because his eyes were shifty or watch his body movements. Those are totally inappropriate. And the Supreme Court did not believe they were innocuous statements like Creighton had said. They don't want to get into a situation where we have to judge the substantive nature of the statements. They just don't want court personnel or third parties interfering with the juries. And that is a admirable thing. And remember, the reason why we have the greatest justice system in the world is because our justice system works for the best of us and works for the worst of us. It can't only work for the best of us. It's got to work for the scum of the scum, like Alex Murdaugh. And, they felt that there was a possibility that his rights to a free and fair jury trial under the Sixth Amendment of the Constitution, Dick Harpootlian hammered on that it's even more powerful than the First Amendment. He said the right of freedom of association, freedom of speech, and the Second Amendment right to bear arms is the right to have a fair and full impartial jury trial. And I agree with that. And so then we went on to the evidentiary issues, and I was very surprised because I believe that it was a correct decision by Judge Newman to introduce the approximately close financial crimes and misdeeds that took place. But the Supreme Court seemed to believe that, based on the questioning, that there may have, and I didn't think they were ever going to comment on the evidence, circumstantial evidence of murder, but they seem to indicate that Alex may have been convicted because he's a scoundrel from the 6 days or 12.5 hours of financial crime testimony that went before the jury, that they convicted him of murder simply because he was a thief. Justice Few said that he thought that testimony could have been garnered in no more than an hour and a half, and certainly not 12 and a half hours. I think if it was anybody else that interfered with the jury other than the clerk of court, if it was like a third party or a truck driver or even a bailiff, it may have been different. But Becky Hill, she holds such a high position of respect and authority in that courtroom, and the way jurors look up to her and the citizens. I think it may have been a bridge too far. I always thought that our Supreme Court wasn't going to reverse this decision, and they were going to make Alex go to federal court, where he probably would have had a more receptive audience if he didn't have one on the state Supreme Court, which he certainly did today. And that federal court would have held that his Sixth Amendment rights were infringed, that the standard should have been the Remmer federal standard, and that they didn't need to get into the state v. Grease standard, where we're talking about shifting the burden to the defendant to prove that the jurors rendered a decision that was otherwise different than they would have, but for what Becky Hill said to them. I think they were also concerned about the experts and how they testified as to the cell phone, and how the ballistics expert testified. There was some discussion about whether it was expert testimony or an experiment, where the guy kept throwing his phone in his office over the weekend and couldn't get it to light up. So there is a possibility that they will remand this back to Justice Toll to have her apply the Remmer standard, but I don't think so. I think they're going to find that there was juror interference by Becky Hill. I just think that she poisoned it so much, especially by her recent plea of guilt. Even though her plea of guilt was not directly related to the jury tampering issue, it was more of the abuse of her office, money issues. There was a lot that came out about the other former clerk of court from a neighboring county, who testified that Becky had said in December that she was going to hope for a guilty verdict, so that she could write a book and make money. That was problematic. But again, there was so much smoke there. One of the justices said that he disagreed with Justice Toll, who only let the affidavit of the egg juror come in and be part of the record, but she wouldn't let her testify. I think the justices would like to have seen the alternate jurors testify as well, especially 741 and the egg lady juror. It would not surprise me if this is reversed. I thought it was only going to be reversed if it was based on the procedural errors of Becky Hill and the jury interference, but that the decision to let the financial crimes come in would remain intact, so that if there was a trial back on the lower court, they would introduce these financial crimes. The one justice was very upset about Tony being able to testify as to his brother, Brian. Brian's a great guy that I represent. I represent both Tony and Brian, and that Brian has some intellectual issues, certainly not disabled or anything like that. There were some words used to describe Brian that I think were pretty inappropriate. Let me see what they were. I had them written down. Let me go to where Scott was. He called him special needs. Brian is not special needs. He's got a little bit of an issue that does affect his cognitive ability, but he's certainly not special needs. But the court said that you introduced that, and that had nothing to do with financial crimes, to Creighton Wooders, and said what it did is made Alex look bad, that he took advantage of somebody that has an impairment. It just seemed like that they were really, really directing a lot of their ire at Creighton. They asked him much harder questions than they ever asked Jim Griffin, Dick Harpootlian, or Phil Barber, who did a good job, I thought, on his 5 minutes or 10 minutes of rebuttal. So we are probably, if you were a betting person, you should put your money that there is going to be a remand for at least a hearing or a new trial. Thank you, Becky Hill. Becky Hill caused this problem. Everybody agreed that they don't want a new trial, that it's going to be costly, it's going to be time consuming. But in order for justice to get right, it needs to be right and perfect. It can't be bruised, it can't be limping to the finish line. Justice has to always be right. And I expect a decision will be from the Supreme Court sometime late spring, early summer. And then it's going to have to be a new trial judge. It's not going to be Judge Newman. So we're going to have find a new trial judge. And a lot of these low country judges have been conflicted out from hearing anything on the Murdaugh matters. So it could end up being an upstate judge who hears it. I don't expect the trial to take place until the summer or fall of 2027, but there will be a new trial. But that was why it was so important for the work that I did and my partner Ronnie Richter and Jason and Justin Bamberg and Mark Tinsley, that we got Alex convicted of all these financial crimes. Because irrespective of whether he goes back and gets the case tried and he's found not guilty or he's got a hung jury and they have to do it all over again, Alex is never getting out of prison. I argued his bond with my partner Ronnie in October of 2021, I think on October 10th or around there. And he was denied bond for the Gloria Satterfield charges. We represented the Satterfield estate and 6 other victims of Alex stealing money and not doing the job that an attorney's supposed to do. And Alex has never gotten out of jail or prison since that day. His bail was denied, and he's never going to get out because he got 27 years, of which he's got to serve 23 in state prison, and he's currently doing that in maximum security prison. He's got to live to be 79, to be able to get out and navigate bad health, bad food, and danger. And when he gets out, he goes to federal prison for 40 years. He'll probably end up serving 34, but that means he's got to live till he's like 115 years old. Not happening. So Alex is going to die in prison. So while we want him to be convicted of the murders of Maggie and Paul, if he did it, and I believe he did, and I believe on a retrial, circumstantial evidence, irrespective of the financial crimes, I think there is so much circumstantial evidence that he will be convicted again. But even if he isn't, he's never getting out of prison. But I guess Alex doesn't want to spend the rest of his life as a double murderer. He'd rather spend it in jail as somebody who stole millions and millions of dollars from clients that he owed fiduciary duties to, the vulnerable, the weak, the people who lost their spouses or their children and needed money, and people who were, catastrophically injured and needed medical care and medical treatment for the rest of their lives. He stole their money, a real son of a gun. And I think Dick Harpootlian wants this off his legacy. That he was part of a trial team that Alex Murdaugh was convicted. And the question is, if he gets a new trial, will Dick and Jim retry it, or will he have to get a new lawyer? Who's going to pay Dick and Jim? Does he have the money? All of those are things. But Becky Hill needs to hang her head low. She was the reason, I think, but with the Supreme Court, if there's a new trial, it's going to be mainly because of her behavior, her plea of guilt, her testimony that they not only did Justice Toll not find credible, but they didn't find credible. And so it was a tough day. We'll live through it again. And if we have to go through the trial, we'll go through it again. It's going to be a circus. It's going to be media again. Everybody's going to be on TV. There's going to be articles. It's tons of money. It's a drain on our justice system. But again, it's got to be done right. That's why we have this system, that we give the same justice and fair trial to people that we think are innocent than we do to the worst of the worst. And if you want to do a top 5 list of the worst ever South Carolina defendants, Alex has got to be on it, if not tops to the list, with Susan Smith, with a you talk about Larry Jean Bell, you talk about Dylan Roof, all those people, they're just scoundrels. They're bad people. And Alex is one of them. He, irrespective of the murders that he may or may not have committed, which I believe he did, stealing money from clients is the worst thing that a lawyer can do. They entrust you with everything. And Becky Hill, Casey Bruton just said the full cost of the new trial should come out of her pocket. She's not going to have anywhere near that money. She's dead and ass broken. Tina Restivo, hello. Nice to see you. So those are my comments. I'm a little bit shocked. I did not expect this. I suspected that the Supreme Court would stand up more for their former Chief Justice, and I never thought that they would attack Judge Clifton Newman, who I thought did a great job. But they did attack him on the admission of some of the financial crimes. They attacked him on admitting some expert testimony on the phone and the gun and bullets. And so I probably have egg on my face because for the last 6-7 months, I've been saying I did not see this coming. I thought that the Supreme Court would affirm the convictions and that if Alex was going to get some relief, it would have to happen on the federal court. But if you were watching, and you don't have to be a lawyer to really feel this way, if you were watching this morning, you would say that the state got punished by the Supreme Court and that the Supreme Court was so much easier on the defense. So thanks a lot for listening, and I will see you later on this week on my Anything But Bland weekly update. You can go to my law firm at www.blandrichter.com, or you can email me at ericbland@blandlaw.com or ericbland@blandrichter.com with any questions you may have. So everybody take care. Over and out.